A multilateral treaty might involve many nations, each of which is sovereign and only bound by the treaty by their consent. Even if nations broadly agree on a policy, it can still be difficult to develop a set of words that every nation will consent to. The traditional response was to allow the use of reservations. A country agrees to the treaty, but subject to a reservation which it sets out in writing. Many of the early multilateral treaties included an express provision which allowed reservations. In 1948, the United Nations undertook negotiations for a treaty banning genocide, just a few years after the horrors of the Second World War. It was intended that this treaty should be unanimous and universal. As a result, it did not contain a provision allowing reservations. Some nations, including the United States, China, and India, entered reservations anyway, saying that their nationals should have immunity from prosecution unless their government consented. So, for instance, you couldn't prosecute an American for genocide without the consent of the American government. This led to consternation in the United Nations. If a country entered a reservation like that, were they actually signing up to the treaty at all? If they were saying that genocide was universally bad, but that their nationals shouldn't be prosecuted without their consent, weren't they saying that genocide was not universally bad? The General Assembly asked the International Court of Justice to advise, can the reserving state be regarded as being a party to the convention while still maintaining its reservation, if the reservation is objected to by one or more of the parties to the convention, but not by the others? The court found that the ability to enter a reservation is a crucial part of the treaty-making process. They said, it certainly could not be inferred from the absence of an article providing for reservations in a multilateral convention that the contracting states are prohibited from making certain reservations. The character of a multilateral convention, its purpose, provisions, mode of preparation, and adoption are factors which must be considered in determining the possibility of making reservations as well as their validity and effect. So even without a provision allowing reservations, they would still sometimes be possible. The General Assembly later accepted that idea by including in the Vienna Convention on Treaties a general principle that nations are allowed to make reservations.